Hi, my name is Brian Prestera. I'm an attorney with the law firm of Gary Myers, Daniel Conway, and Associates. I'm here today to talk to you about security clearances and more specifically, suspension or possibly losing your security clearance. As a civilian or DoD employee or contractor, or even as a service member, your security clearance could mean your entire career and your job and your livelihood. It's critically important and it can be gone like that. Now, security clearance investigations are very unique in the law. It's one of the few areas where the federal government requires you to prove that you are not a threat. The law does not require the government to prove that you are a threat. So the burden is on you, and that's why it's critically important to contact an attorney early in the game when you've been notified of a possible suspension so that we can start digging into all the facts and answering all the questions very specifically. Now, the process works a little bit like this usually. When there's a red flag, or it could be part of a normal security clearance screening, or even sometimes you can get an anonymous tip that someone puts in against you for security clearance or potential security clearance threat. You're first usually notified of a request for information where the security clearance office will ask you for answers to particular questions or answers about particular facts and circumstances so that they can further investigate whether or not you're a potential threat to the United States government. Responding to these questions is the critical first stage of saving your security clearance. It's very important to gather all the correct evidence and very specifically and diligently respond to those questions, answering all the concerns of the security office. If you don't, and if the security office is not satisfied with your responses, the next step is that you're going to get an initial letter of intent to suspend or revoke your security clearance. Again, you have an opportunity to respond, and we can help you with that to gather additional evidence and additional facts that may be needed to bolster your case to prove that you are not a threat to the United States government. If after submitting that appeal you still are faced with additional security clearance action, what will happen is you'll get what's called a letter of denial. That's your official and first official letter denying you security clearance or telling you that your security clearance has officially been revoked. Now, there is an appellate process if you get a letter of denial. You can appeal in writing or you can appeal in person with attorney representation at a DOHA, Department of Hearings and Appeals, hearing before an administrative law judge to plead your case as to why you're not a threat. I cannot stress to you how important it is to have competent, diligent counsel representing you at that phase of your appeal, because it is the last chance that you have to prove that you are not a threat. And remember, the burden is on you to prove that you are not a threat. So, give us a call. Talk to us about your situation early in the game. And even if it's not early in the game, give us a call because we may be able to step in and help you out later in the game to still save your security clearance. We'd love to talk to you about your circumstances and give you any help that we can in this difficult process.